Hopefully, yeah, Chidi will be here in a minute. So I just wanted to start by welcoming everyone to our webinar today, Africa's New Treaty on Statelessness and the Right to Nationality, How to Make It Work. My name is Ashley Manth-Hollins, and I'm a research fellow and global sit coordinator at the European University Institute. So for those of you who are kind of new to our webinars, Global Sit, or the Global Citizenship Observatory, is an online research repository and network that collects and analyzes citizenship laws and electoral rights around the world. Now, we've been very much looking forward to this webinar, which will be part of a series over the year that will look at different aspects of citizenship law across various regions of the world. So keep an eye out for information from us soon on our next session. Now, I'm delighted to introduce our speakers today, who will each speak about different parts of the African Union's 2024 adoption of the protocol to the African Charter on Human and People's Rights on specific aspects to the right to a nationality and the eradication of statelessness in Africa. They'll speak about the antecedents to its process, the pros and cons to implementation, and implications for stateless persons. We'll start with Chidi Odinkalu from Tufts University. Hopefully he will join the session any minute. Then we'll go to Bronwyn Mamby from the London School of Economics. Then to Ibrahima Kane, formerly from the Open Society Foundation. Then Tadeka Choke from the Global Movement to End Statelessness. And finally to Christy Chitengu from the Global Movement to a global movement against statelessness. So each speaker will have kind of 5 to 7 minutes to talk about different aspects of the protocol, and that should give us a little bit of time at the end for a Q&A. And I think, yeah, Chidi is entering the room right now, so perfect timing. So Chidi, are you here?
Yes.
Great. So we thought we'd thanks for joining us, and we thought we'd start with you, and then yeah, so you have 5 to 7 minutes to discuss to sort of set the stage for us. So go ahead.
Hi, Ashley, colleagues. Good day. I hope everyone is alive and reasonably well. Well, I guess the road to the protocol has been fairly far-reaching. Depends on how you cast it. You could say it started with the so-called the transition to democratization, I think, which magnified a problem that has been there before. I don't want to go into why it's been there before because we can get back to it when we get into conversations. But the weaponization of post-colonial identities in many ways by African governments at the beginning, particularly of the decade of the 1990s, um, reminded us of what the challenges were and led to problems in a lot of countries across Africa. Um, I think many people will probably remember that on a day in April 1999, the government of Fred Chiluba in Zambia put an aircraft, sorry, it's the beginning of 1999, they put an aircraft at the airport in Lusaka and decided they were going to export, and I'm using export deliberately, so nobody should think that I'm not. My English, I know English is my third language, but I'm using export very deliberately here. They decided they were going to export Kenneth Kaunda, the founding president of Zambia, to Malawi, where his parents reportedly came from. Um, and That case ultimately was fought in different directions up to the Supreme Court of Zambia, which the following year, 2001, ultimately annulled that step and could calm nerves. The Zambian government then enacted a constitutional amendment which altered things, forcing Only those whom it claimed had two parents of descent from Zambia by birth to be presidents. And this was at a time to be able to run for president. This was at a time when Kaunda was thinking of returning to power in Zambia. That went up to the African Commission on Human and People's Rights, and the commission ruled it out of order as having violated the provisions of the African Charter on non-prohibiting discrimination and also guaranteeing right to civic participation at the national level. Now, while that was going on, Cote d'Ivoire was being roiled in many ways, ultimately resulting in the preclusion of the man who incidentally is now Cote d'Ivoire's president from running for office to the presidency in Cote d'Ivoire on the basis that he was not Ivoirian enough. So the notion of Ivoirité came up. Who is Ivoirian enough and who isn't? In Tanzania, it turns out Kaunda's nephew, who was the first commissioned officer in the Tanzanian armed forces, was being run out of town, ultimately chased down back to Zambia, where his uncle was also going through his own problems. And in Botswana, also those issues were coming up. Now, these issues were being resolved at two different levels. You had the rather confounding case of a Botswana opposition politician who was denationalized 3 different times, expelled from Bophuthatswana into South Africa, back to Bophuthatswana, into South Africa, back to Botswana, into Bophuthatswana, back to South Africa. And the dehumanizations that were coming up out and violations that came out of all of these politically motivated denationalizations began to generate 3 things. One was national level jurisprudence. The second was political instability in many ways. As a result of Ivoirité, for instance, Cote d'Ivoire went to a civil war a second time. And as a result of that, Zambia came close to a constitutional meltdown. And as a result of these issues, the third response, of course, was jurisprudence at the continental level. And it was these set of developments that ultimately led us, I think, Bronwyn, who is here, and Ibrahima, who is here, were also there when we convened in Kampala in 2007 to explore these issues and what could be done about them. It clearly had become an issue. And interestingly, these were issues that actually were there present in the continent in the first generation immediately after independence. And if you look at the AU Refugee Convention, Article 2, 3, I believe, Article 3 deals with the prohibition against subversion. That prohibition against subversion actually is where this issue started, which was the transboundary flows of populations whose nationalities were fluidities introduced by Uti Posidetes, which were people who were fighting for liberation, needed homeland somewhere, but were based in other places, and what had happened with them in the post-colonial settlement. Now, those issues then reverberated in the historical context I've provided, which led to the Kampala meeting in 2007, where the agreement was reached for us to begin the advocacy towards what ultimately became this protocol. I'll yield, and because I'm sure that there'll be many more people who'll be developing the narrative from here. Thank you very much.
So shall I take over straight away? So Tiddy was the leading figure behind convening the meeting in Kampala in 2007. To fast forward very quickly, from an NGO exercise, that meeting involved members of the African Commission on Human and People's Rights and members of the AU Commission, the Secretariat of the African Union. But the substantive debate moved into before the African Commission on Human and People's Rights, where Chidi, myself, Ibrahima, and others were involved in drafting a text and advocacy for the African Commission to adopt a draft text of the protocol, which it finally did in 2015. So that's already 8 years from the sort of first idea of a protocol. The African Commission then met with the AU Commission to try and move this into an interstate process. The AU's Council of Ministers approved the concept of a protocol in 2016, and then a process of interstate meetings before two different what are known as specialized technical committees in the constitutive act of the before the African Union, which are kind of meetings of ministers on themes. So the first set of meetings were the STC on migration, and the second meetings were the STC on justice and legal affairs, which has to approve any legal document. That process took place 2017 to 2018, and then into before the STC migration. And then with a delay caused by COVID, timetabling, background, politicking, the next set of debates before the STC, Justice and Legal Affairs, happened in 2022 and then 2023, after which it was forwarded to the Summit of the African Union. The dynamics in the interstate debates were, of course, very different from those amongst the NGOs. The main supporting states were the West African states. I mean, ECOWAS, Economic Community of West African States, which is 15 states, as a community took a position in favor of the protocol, but also individual states were very important in supporting the protocol. The main opposing group were the North Africans, especially Morocco, Algeria, Egypt, especially Egypt. Kenya and Zimbabwe were opposed at different times. South Africa was a bit on the fence, took different views. Certain countries were opposed or against according to who happened to be in the room and what their background was. There was quite a lot of variation that way. But the North Africans were the principal opposing bloc. We were assisted by the fact that Algeria and Morocco don't officially talk to each other because of Western Sahara, which prevented a degree of more effective coordination. Just in terms of the key issues that were mainly debated, mainly contentious, the first one was, what is the status of the protocol? Just as in the context of the European Convention on Nationality, which was originally proposed as a protocol to the European Convention on Human Rights, the North Africans and others proposed that this should be a freestanding convention. It should not be a protocol to the African Charter, with, of course, the transparent objective that therefore the protocol would not be subject to oversight by the African Commission on Human and People's Rights. They lost that debate. Another parallel debate was, no, it shouldn't be about the right to a nationality, it should be about statelessness and restricted very much to statelessness. So essentially a version of the 1954 protocol about protection of stateless persons, and with a little bit about facilitated naturalization, maybe. I should point out that the African Charter on the rights and welfare of the child already has a provision on otherwise stateless children born in the territory. So most African states are already committed to that basic protection. A rearguard action that was fought throughout the discussions was putting in qualifying language on every single provision saying, except as national law otherwise provides, subject to national security, all of that type of stuff. Most of those provisions are in there. They are, of course, of concern, but it is likely that the African Commission would interpret them out of existence when it came down to it. In terms of the sort of core automatic attribution of nationality at birth and the right to acquire nationality at a later date, the single most important advance of the protocol is the rule of double jus soli. So it provides that nationality shall be automatically attributed to the second generation born in the country. And that was really thanks to support from the West African states, especially the Francophone countries, which apart from Côte d'Ivoire already have that provision and able to support it quite strongly. There was also a certain amount of, and a number of states were very unhappy about that, but nonetheless it went through. Otherwise, descent-based non-discrimination based on parentage, not controversial apart from Egypt, which did manage to get some language in there that put some qualifications on it, but otherwise not controversial. The naturalization article, which initially had a whole list of facilitated naturalization provisions, was essentially deleted, and it simply says facilitated, there shall be a naturalization provision and facilitated naturalization for stateless persons. And in the context of that debate, even acquisition based on marriage was deleted. So it was much more, that was really knocked out of the ground. Otherwise, maybe another provision that will be of interest to many people here is dual nationality. So initially, there was a provision which provided for dual nationality for children along the lines of the European Convention on Nationality. That was relatively uncontroversial until really at the very last minute. I mean, Ethiopia had objected previously. Ethiopia allows dual nationality in no circumstances, but had previously been overruled by other states. But at the very last meeting, they managed to get that provision deleted. So the protocol says nothing explicit about dual nationality, but the other provisions, especially on loss of nationality, imply that dual nationality you cannot automatically lose for acquiring another nationality. So it requires, in essence, an act of the state to take nationality away on grounds of dual nationality, even for adults. And for children, it's a little ambiguous. It's the provision was deleted, but consequential amendments were not made, and so it ends up being a little ambivalent. I shall leave it there, I think, and happy to answer questions and hand over to Ibrahima.
Thanks. Yeah, Ibrahima, the floor is yours.
Yes, thank you very, very much for the floor. And, following Chidi's and Bronwen's comments, I think I will want to present the protocol itself. This is, as Bronwen said, a compromise between African countries. All these countries, when they got their independence, used the colonial legislation that was left by the colonial masters. And part of the problem that we face at independence that Chidi mentioned was related to the fact that many of these things were colonial legislation. So we needed to decolonize our laws on not only the right to a nationality, but to deal with also statelessness issues. So the first idea of this protocol is not just a common position on an issue, but a way to decolonize the right to a nationality and to have an African legislation on the right to a nationality. So when we look at it in that way, we realize that we change the language on many, many issues, those issues that were not really taken into consideration in some African countries, because people should not forget that we inherited different legal systems, Francophone, Lusophone, Arabophone, common law, and those things were creating a lot of problem when you consider that in Africa, we also have sub-regional mechanisms that we call economic community. And those economic communities are trying to develop common understanding on issues. So if we don't take out these colonial issues, it will not work for African countries. So that was the first idea. The second idea was to look at the specific problem that Africa is facing, and that are related to nationality and to statelessness that can be dealt with. Border issues, the issue of civil status. Don't forget that on the continent, only 50% of Africans have birth certificates. The issue of pastoralism, because the quarter of Africans are pastoralists. The only border that they know is the grass. And they leave from West Africa, from Mauritania to Sudan, or in other regions, they have their own route. These are millenary routes that they were using. People go with their families, children are born. What is the nationality of those children? And peace and security. You know, up to now, if you look at our continent, it's still facing with security issues. Security issues in different angles, not only the fact that you leave your country without any document, anything, you know, you just run away to save your life. And then after, without any document, you have to deal with the situation, the consequences of that. But also, because you were denationalized, you take your guns and say, I want to be recognized as a citizen of the country. That's what happened in Cote d'Ivoire, for instance. So all those situations created problems that needed to be resolved. But lastly, which was even something that came after African countries got their independence. If you all remember, in 1963, when the OAU was created, it was created with the ideas that the border that we inherited from colonial masters have to remain. We don't change those borders. But then after, Ethiopia was separated with Eritrea. Sudan was separated with South Sudan. A decision of the International Court of Justice decided that the territory of Bakassi doesn't belong to Nigeria, but belong to Cameroon. On all those territories, there were populations. So the nationality issue remained because there is no single solution accepted by at the international level on the nationality of person in the case of succession of states. So Africa had to invent those kind of norms, despite the work that the International Commission of Law did in the past. So for all these issues, the treaty that we adopted really dealt with some of these issues, but in a very, very elaborated manner. For instance, when you look at the whole issue of nomadic and cross-border communities, you know, the problem is what are the consideration, what are the standard that people can use to as evidence of appropriate connection of a person with a territory. Place of birth, place of marriage, repeated residence in the same location, the presence of the family, the cultivation of crops in an annual basis, you know, many, many other things. These are the reality of the continent. It needed to be taken if we really want to eradicate this phenomenon that is creating a lot of problem on the continent. But I need also, apart from those issues, to highlight one fundamental issue that was sorted out this year, the proof of nationality. Again, I come back to what we inherited. You have legal systems that have proof of nationality clear, like in the civil law system, where you have certificate de nationalité. But in the common law system, you don't have. Some people need affidavit, some people need this, some people need that. At least this one came with the idea that now we have documentation of a nationality. And states should have documentation of the nationality, and those documentation can really help to clearly identify the nationality of the person. These are some of these, I think, clear evidence of the move that was made in Africa. And maybe lastly, because of the experience that we had in the past, Chidi mentioned many of them, John Modise's case, Kenneth Kaunda case, you know, those are the cases that are really popular. But how many Africans was deprived of their nationality in a very arbitrary manner? So now there is provision regarding this issue of deprivation of nationality. And these are some of the problems that we were, the continent was dealing with. And that helped to really resolve the issue of the recognition and the protection of stateless person. And finally, it also helped to find rules and procedure relating to nationality that state needs to put in place to make it possible. So my last point for this conversation, for this introduction, will be the provision on cooperation among states and with international organizations. Issue of nationality, issue of statelessness cannot be sorted out in one country. It's collaboration between states, particularly given the fact that African borders are not clear. According to the AU, only 19%, less than 20% of African borders are demarcated. So if there is no cooperation between member states, there will never be a solution to statelessness and issues. And I'm glad that this treaty has been officially last year in December, officially launched by the African Union. And I think the symbolic aspect of this treaty is that it is the contribution of the African continent to the decade of the eradication of statelessness launched by the UNHCR and that contribution of the African continent to the decade is really, really important. It's really, really good because it will help, in our view, to really give existence to millions of Africans who otherwise are still not a human being. They still exist as, physically, but legally speaking, they don't exist. And this treaty can really help to deal with that matter. So that contribution of the African continent is really very important.
Thank you so much, Ibrahima. Tandeka, can we move on to you?
Absolutely. Thank you, Ashley. Now, if you're not already convinced by Ibrahima that the adoption of this protocol is really a crucial and important moment for nationality law and for the protection of stateless persons in Africa, now you should be, right? But as many of us know in this room, the adoption of a legal instrument or treaty is only the beginning of its life. And what really matters is whether the protocol actually changes how states act, how institutions behave, and ultimately how people experience the law. So I will just focus on 3 practical questions, which is how states ratify the protocol, how they implement it, and how they're held to account over time. So firstly, with ratification, we know that this is often treated as a technical legal step, but in reality, it is a political one. And states do not ratify all instruments in the same way or even at the same speed. We know this historically with AU treaties. Experience from previous treaties has shown us that ratification is more likely where the protocol actually connects to existing legal frameworks, to existing jurisprudence or court decisions, or even with policy priorities. There needs to be some sort of alignment. And so this means that advocacy for ratification needs to be context-specific rather than a one-size-fits-all approach. And I think framing also matters. It's very critical. And what might be strategic in efforts to push for the ratification of the protocol is presenting it as something that is already part of a coherent and comprehensive body of human rights law from the regional system. So this is not necessarily pushing for states to be adopting or taking on new obligations, but more about making existing commitments coherent and consistent. So we already know, for instance, the African Charter enjoys almost universal ratification. So there are those overlaps with children's rights that matter for the treaty. There are already states that are focusing proactively on addressing issues of gender equality. And we know that gender inequality nationality laws is still one of the causes that drive statelessness in the continent. And then there are also efforts around migration and even access to legal identity that we could leverage as advocacy points. And second, looking at implementation, I think it's critical to highlight that the way statelessness manifests is not only because of challenges with the law, but by the way the law is applied through administrative systems. And I think this is very crucial in the African context. So for the protocol to have any real effect, states would have to translate its principles into domestic laws and regulations, into clear procedures for nationality determination, and even guidance and training for officials who apply these rules in practice. And we know that strategic litigation can play a very important role in this regard, but I think it's also important to underscore that court decisions alone are rarely enough. Without changes in administrative practice, we often see legal victories that remain limited to individual cases rather than broader systemic reform. And the final point is around accountability. So even when states ratify the protocol, there's a need for ongoing oversight. And without it, we can also see implementation that is either uneven or selective. And now the African human rights system provides several avenues for accountability. So these are reporting processes with the African Commission, with the African Committee for Children, engagement with special rapporteurs, and even the work of the courts and quasi-judicial borders. These processes are important not only for enforcement, but also for clarifying how the right to nationality should be understood in practice. And over time, they would also help build a common and shared understanding of what the protocol requires of states and how it should be applied. So finally, I'll also maybe touch on the wider continental context and highlight the fact that the protocol does not stand alone. And one particularly important tool is the Pan-African Parliament Model Law on Nationality and Statelessness. And this model law actually offers practical guidance to states on how to align their domestic laws with continental standards. And this model law can actually help bridge that gap between regional commitments that are often phrased in very ambiguous language to national legislation that is actually implementable and making more implementation more concrete and achievable. And then this is my third final point. Ibrahima had 5 final points, so I think I'll be excused. But I'll end with this point that many of the principles that are reflected in the protocol, of course, as we've heard the narrative, did not emerge from diplomatic negotiation alone. They were shaped by litigation, shaped by civil society advocacy, but also most importantly, the lived experience of people who are in fact impacted by statelessness. And I think my point is that if the protocol is to have any meaningful impact on statelessness in Africa, then it must remain connected to these lived realities. Otherwise, there is that real risk that what is a well-drafted instrument exists mainly on paper. We just have a paper law that doesn't become a people's law. So ultimately, the success of the protocol should be measured not only how many states ratify it, but by whether it actually changes how Africans conceive and understand the notion of belonging and how they administer citizenship across the continent. And there's a lot of work that's been done by the global movement to center lived experience and advocacy, as well as regional networks such as the Pan-African Nationality Network, the Southern African Nationality Network, and the East African Nationality Network. Thank you very much.
Thank you so much. And I pass the floor to Christy.
Thank you so much. I want to reflect briefly on 3 things. One, which is what the protocol means symbolically for people who are impacted by statelessness, and also what the protocol offers as a legal and advocacy tool. Firstly, at a symbolic level, the protocol matters simply because it names statelessness directly within the African human rights system. It also importantly affirms what it means to belong and distinguishes from the objective requirement of having a birth certificate or identity document that many stateless people do not have, to considering very subjective personal ties a person has to a specific country, whether that's based off where descendants are buried and where the grazing patterns of that community happens. It goes deeper beyond just the objective legal documentation that people can't always present. And this also feeds into the and is an expression of the principle of Ubuntu, which a lot of Africans follow, which means I am because you are. And so it's useful to know that is coming across in how the protocol has been drafted and expressed. For the longest time, statelessness in Africa has existed as a legal shadow, and it shows up indirectly through children's rights, as it was indicated earlier, through the dignity and equality, but really as a standalone injustice that requires its own response. And so the protocol changes it by explicitly recognizing statelessness as incompatible with human dignity and as an obstacle to the enjoyment of other rights in the African Charter. from a lived experience, that recognition matters more than it might appear. Statelessness is not just about lacking the documents. It's about existing in a legal system that doesn't quite know what to do with you. And being explicitly recognized in law shifts that dynamic. It signals that the problem is not an individual failure or an administrative accident, but something more structural that a state has an obligation to address, and states need to work collectively, as was indicated earlier, to address that. So that gives it much more weight than previously. What is also significant is that the protocol situates statelessness within the African historical social realities, as was expressed by Ibrahim earlier and earlier speakers. The colonial borders, state succession, nomadic and cross-border communities, those are the histories that we need to address as we address statelessness. And this matters because many global frameworks on statelessness don't reflect the African context. And symbolically, the protocol says that this is an African problem shaped by African histories and deserving of African solutions. My last point is with relation to how this protocol can be used as a legal and an advocacy tool. And so beyond symbolism, I think that the real strength of the protocol lies in how it clarifies and consolidates legal principles. It brings together in one instrument ideas that were previously scattered across various protocols: the right to nationality, the prohibition of arbitrary deprivation, and the prevention of childhood statelessness. So it really just brings it all together in one legal document. And this consolidation makes it clear for regions and scholars and institutions to refer to and use to hold states accountable when there is that national level litigation. There are also provisions that that speak directly to everyday harm, such as emphasis on the emphasis of nationality, the acceptance of oral testimony, and the shifting of the burden of proof when someone holds state-issued documentation. These are not abstract rules. They address a very common experience of statelessness within Africa. And as an advocacy and legal tool, then the protocol is not just about these grand principles. It provides the language and the standards that states can take forward. Whether or not the protocol will be meaningful, given low ratification at this point, is a question to consider. I think more from the ratification, although important, only focusing on ratification could risk misunderstanding how the change historically has occurred. And so what the protocol does, it shifts this baseline, and it becomes harder for states to justify discrimination. And from a lived experience standpoint, I would definitely add that it is relevant, and the legal recognition usually arrives after a long harm has been experienced, but it still matters because it determines whether future exclusion is how future exclusion is treated, and determining that is unlawful. Thank you.
Thank you so much, Christy, and to all of our speakers for this very full picture of the protocol and all of its different components. So I'd like to open up the floor now for Q&A. So feel free to use the raise hand function, or you can also put your questions in the chat, and I can collect them, or you can let us know if you have a question directed at someone in specific, or if you just have a general question to all of the speakers. Martin, yes, go ahead.
Yes, thank you, Ashley. And first of all, congratulations to everyone involved in this major milestone, I think. And it's really a major contribution to international law and also to nationality law in Africa. I have a question, I think, especially to Thandeka. So thank you very much for talking more about the implementation of the protocol. And I have a question about the interpretation, the legal interpretation that would eventually come after, I think, at least 15 states have ratified the protocol. So I see in the text that it refers to interpretation by the African Commission and, where applicable, the African Court. So that sounds like a recipe for trouble. Maybe what is your view on this? How might this work?
Sure. Teneka, why don't you go ahead and answer that one, and then we will give the floor to Robert and Bronwyn, who both have raised their hands. Just unmute yourself, yeah.
Do you know, I wonder if I can pass on this question to Bronwyn.
Yeah, which is why I raised my hand.
Oh,
yeah.
sure. Okay, go ahead, Bronwyn.
So that clause went through quite a lot of arguments among states, because the architecture of the different treaty bodies, we can call them human rights institutions at the African Union level, is very complicated. So this is a protocol to the African Charter on Human and People's Rights. If you are a party to the African Charter on Human and People's Rights, you automatically accept the jurisdiction of the African Commission to hear complaints, and by extension to the protocols to the African to the African Charter. There was a lot of argument trying to make that not happen. Separately, we have the African Court on Human and People's Rights, which has jurisdiction over any human rights treaty to which the state is party. But there are only, I think there were 6, and now there are fewer states that have accepted the right of individual complaint. So otherwise, only cases being heard by the African Court are interstate complaints or cases referred by an African Union institution. The whole debate, which is it was in the December 2023 meeting, where the sort of main debate was this, it had come up before, with those states that have no intention of ever, allowing anything to be heard by the African Court, wanting to stop the African Court, whose decisions are nominally binding, whereas the African Commission's decisions are nominally not binding. They wanted to prevent the African Court from ever having jurisdiction over any of these provisions. A very hypothetical, decades down the line type of decision, given that they're not accepting the right of individual petition anyway. But so the where applicable language was a compromise piece of language that was fought over in the room where the states were debating, to say that for some, effectively giving some states the sense that they would be able in the future to make the argument that the court did not have jurisdiction, and other states to argue that yes, in fact, it is applicable and they do have jurisdiction, and it has ended up being ambiguous.
Thank you, Bronwyn. I'll give the floor to Robert, who has raised his hand.
Thanks. My question is to Bronwyn. You did indicate in your intervention that the West African countries, especially from ECOWAS, did show great support for the protocol at the beginning. But why has that not translated into the ratification and the accession into the protocol? Because we know that for the protocol to enter into force, we need to have 15 ratifications. So I would have expected that by now, which is, I think it will be 2 years this month, February 2026, since the protocol was adopted. I'm not sure whether there's any country that has actually, completed the process of ratifying and acceding to the protocol. Is it an issue of processes, that has to take this long, or is it an issue of lack of willingness, which could be the case for those countries that initially were opposed to the protocol, or a bit hesitant, like maybe the countries as you indicated in eastern part and southern part of Africa? But if the countries in the francophone countries were had shown the initiative to support the protocol, why have they not concluded the process of ratifying so that the protocol can automatically enter into force? Thanks.
Yeah, I mean, I'll hand over to Ibrahima just now as well, who's been involved in some, advocacy on the ground as well. I mean, one challenge that was already a challenge in the final meeting before the STC on Justice and Legal Affairs is that ECOWAS is, you've got 4 countries currently under military rule. They are suspended, or I don't know how many are exactly suspended at the moment, but some key states who are supportive of the protocol were not present in the final meetings, and therefore their voices were not present. We were also completely, I mean, sort of random things impact some of the final amendments, such as the African Union, in its wisdom, moved the date of the meeting on 10 days' notice by 1 week. And so, various state delegates couldn't attend because, you've got to commit to being in Addis Ababa for 4 days from wherever it is that you are normally based in your capital city. And the meeting was just suddenly shifted. I mean, so you end up with only the states that have more resource and more other people who could be sent were in the room, notably North African states. So I think, there are, Cote d'Ivoire, Benin, others were going to be ratifying. Ibrahima can maybe update us. I think Rwanda had committed to update as well. Another challenge here is that UNHCR throughout this process played a really important role in convening meetings to enable, mostly virtual, but some physical meetings also at a regional level, to enable states to be able to debate with each other and come to common positions and common understandings of what was going on. The national focal points that UNHCR had facilitated for statelessness played a key role in this discussion as well. Since last year, of course, UNHCR, which might have been convening meetings, no longer has any money. So that's also a factor. But Ibrahima, I'll hand over to you on West Africa and ratification.
I think the first thing to say about ratification is that there is a tradition in Africa about ratifying very late treaties. Apart from 2 treaties, the Constitutive of the African Union and the Protocol on the Right of Women, which were ratified in 1 year or 2 years, the minimum time frame for the entry in force of treaties in Africa is 5 to 6 years. We are still in that time frame. The problem this time is also something that you mentioned, because when the treaty came into force, there was already a strategy that was put in place in relation with the UNHCR to really start the advocacy plan. But then the UNHCR itself went through some financial problems and it stopped the process. Last year, I mentioned in November, there was an official launch of the treaty, which was also a way of putting some pressure on member states in Addis to really start commit themselves about ratification. And I can confirm what you have said, because many states have participated to that meeting, and some of the states have already started the process at the national level. Cote d'Ivoire started, but you remember last year in Cote d'Ivoire, nationality issues came again about the election. So it tampered a little bit the process, but now that all those are over, I think the process will start. I want to use this opportunity to really also call on all the Africans that are participating here and that have connection with member states to really urge these member states to do something about it. Because, if we don't do this kind of work, if we don't organize, for instance, you mentioned the protocol to the African Charter on the African Court. This protocol was also adopted 5 years after only 3 or 4 countries signed it. We had to organize regional meetings to really encourage and eventually force states to do so. So here the call that I'm making is really, can we all mobilize to really push for the ratification of the treaty? If we can make it less than 5 years, for me, it will be perfect. But let's first at least force countries to sign, then to start dealing with the ratification process, because the signing already is a commitment. So let's try to do something about that. And I know that the African Commission already and the Committee on the Right and Welfare of the Child are doing something about it. Back to the floor.
Thank you so much, Ibrahima. So I'll read it. We have a question that came up in the chat and from Thomas McGee, who's Max Weber Fellow at the EUI. So he says, thanks all. A general question for anybody who might like to take it. Unless I'm mistaken, it looks like the protocol is using the definition of a stateless person found in Article 1 of the 1954 Convention relating to the status of stateless peoples, but without anywhere referencing the convention directly. I'm wondering if this was a conscious decision to avoid referencing the convention by name, perhaps not to deter states that are non-signatories. Noting that Article 1 of the 1954 Convention has been considered as part of customary international law. Bronwyn, did you want to take this question? Yes, okay, thank you.
Yeah, I mean, I almost touched on this in my introductory remarks as well. So the draft protocol, as adopted by the African Commission on Human and People's Rights, the definition is the 1954 Convention. Any person who is not considered as a national by any state under the operation of its law, including a person who is unable to establish their nationality. So that the version as adopted by the African Commission on Human and People's Rights had that important addition. That actually survived with controversy all the way through the first round of state discussions before the STC, Specialized Technical Committee on Migration, but was ultimately deleted by the STC on Justice and Legal Affairs. I think states were nervous about what it might mean. You know, suddenly you're going to have to give nationality to a lot more people. There was a lot of pushback from other states saying, well, that's exactly the problem in so many African countries, is that people, if they narrate their family history, it's clear that they are a national of 1 or 2 or even 3 countries, but they can't establish it to the satisfaction of the relevant authority. So those people should be counted as stateless and therefore given the protection and the rights of stateless people. I don't know the significance. I mean, you know, we would only find out, you know, if they had adopted that definition, what impact it might have had in due course. But more generally, in relation to your specific question, this is an African treaty. That's very clearly, it's based on African jurisprudence, the African precedents. Obviously, you know, there's a whole explanatory memorandum that explains the international precedents for that were drawn on. But in general, I think states, you know, they were reluctant to mention, for example, cooperation with UNHCR, saying no, we're not committing to cooperation with the UN. This is a treaty for the African continent.
Thank you, Bronwyn. Yeah, maybe I'll use my position as chair to ask a question to Thandeka. You mentioned in your talk how ratification sort of advocacy for ratification needs to be context specific. And I was wondering if you can give us maybe a few examples of kind of what's worked and where.
So examples are, for instance, looking at perhaps countries that have already ratified other instruments that deal with the right to nationality. So for instance, the Maputo Protocol already has provisions that deal with gender inequality nationality law. And then I mentioned the example of leveraging the fact that there's near universal ratification of the African Charter for Children. So those could be low-hanging fruits to leverage advocacy on, framing it as a child rights matter, highlighting it as a gender equality matter, and then also an opportunity to assist states in dealing with the context of border communities and pastoralist communities, because we often find them running away from addressing statelessness amongst those communities because they find it complex and don't have adequate determination procedures to adopt for that context. And I think this is really also where the Pan-African Parliament's model law comes in handy, because it's also used those provisions as per the language of the treaty, but broken it down into what could actually look like a domestic citizenship law, and actually setting out what due process in some of these processes could look like. And I think it's also important having that context that Bronwyn explained with the countries that had particular opposition to particular provisions. So, for instance, knowing that advocacy around the gender equality provision might be tricky in Egypt, but knowing that that might be something that we could push for in Eswatini, but adopting a more customary approach to addressing these issues. So I think those are maybe some examples to think about, and that we've seen civil society using those approaches already in different contexts.
Thank you so much. And Bronwyn's actually turned the question also over to Chidi so she writes in the chat for Chidi to also answer in relation to view on likely ratifications and impact on the ground, given your experience of litigation before the ACM HPR and in Nigeria. So, Chidi, do you want to take the floor?
I don't know. Maybe 2-3 things. First of all, going back to the question about West Africa from Robert Waweru. I think it's fair to say also that with the West African country, a country ECOWAS has been in transition for the past 2-3 years. With the situation concerning the Alliance of Sahelian States. And that's kind of stalled initiative on regional multilateralism in many ways and consensus on several things, including, of course, the kinds of things we are discussing here, while they're sorting out the transition between the 12 and the 3. Because they've got to address questions of community citizenship, amongst other things, and also free movement of factor mobility, particularly free movement of persons, which are in many ways are related, at least in terms of attitudes, if not detail, to the question of the broader question of statelessness. And my sense is that once that there's clarity on those issues, it may be easier to achieve swiftness on regional consensus, broadly speaking. But the second thing is, broadly speaking, again, I agree with Thandeka. Ratification, and Ibrahim, I think, made the point. Treaty ratification in Africa is contact sport. It's very relational. I mean, Ibrahim and I quite literally went country to country collecting ratifications for the African Court Protocol. It took us 3.5 years. And we went first region to region and then country to country. And at a point, started doing foreign minister to foreign minister. And it's go along, there are 2 things I think that are critical. One is the people who do the STC work in Addis are mostly technicians, and then, of course, the permanent representatives. They're not the politicians who have got to do the instruments domestically. And for those politicians who've got to do this, and there is actually quite a huge disconnect between Addis and the capitals. For us who are advocates, we kind of think everybody is state, and therefore we default to the idea that there is lack of political will to ratify. I don't think that's the case. Certainly that's the experience. I suspect Ibrahim will probably say the same thing. It's actually lack of information and not knowing that these things exist. And we've got to plug the gaps between Addis and capitals. And that's where I think the context comes in, being able to pass the message. We're just at the beginning of another ratification campaign now for the Malabo Protocol, getting the countries we need to be able to do that. And we are expecting to have a meeting with the Sierra Leonean government convening West Africa as the chair of ECOWAS in March for us to get the West African countries locked down. But it took 2 visits to Angola to get Angola's ratification done. From myself representing interests also represented by Ibrahim. And I do think that if we're different countries will have different messages. I could easily see how I sell this protocol to Nigeria, for instance, which would be different from how I would discuss it if I were with the president of Ghana or the foreign minister of Ghana. And I do think we've got to kind of decentralized that way in order to be able to achieve ratifications. Country-specific messaging will be very critical.
Thank you so much. Yeah, we are run 2 minutes over time, but this was such an interesting conversation. And I just wanted to thank all of our presenters again so much for taking part of it and for everyone who joined in the lively discussion. Yes, I hope you all have a fantastic evening or day wherever you are in the world, and see you again soon.
Thank you very much.
Bye. Thank you.
Thank you.
Thank you. Bye.